Welcome to Complex Conversations. In this podcast, we hope to make complex living simple by explaining the law related to sectional title schemes, homeowners associations, and other types of community schemes in South Africa. I'm Jennifer Paddock, a dual qualified lawyer and director here at Paddock's, a specialist community schemes law and training firm. In this fourth podcast episode, I want to talk to you about body corporate resolutions and explain all the requirements in order to legally pass ordinary, special, and unanimous resolutions. And while this may seem like a simple topic, I can tell you from experience that it is very often misunderstood. In Paddock's Club, our online coaching platform where we give community scheme members advice, the issue of how to pass resolutions comes up all the time. What is the notice period required for each of these resolutions when they're being passed at a general meeting? What is the quorum requirement for the general meeting? What is the consensus level for each type of resolution? Must the votes be counted in number or value, or both? When do these different requirements apply? And so in this podcast, I'm going to summarize all of the basic requirements, and I'll also attach a cheat sheet for you so that you can have them at a glance. So we'll be talking about the three different types of body corporate resolutions: ordinary, special, and unanimous. The two different ways that each of these resolutions can be taken at a meeting or in writing, how to calculate votes in number and value and when to use each of these calculations, how to take ordinary, special, and unanimous resolutions at a general meeting, how to take them in writing, and finally, which votes should be excluded. So let's start with the types of resolution. As I said, there are three types, and all body corporate resolutions are taken by member resolution. This is decisions taken at the owner level, at the body corporate member level. We're not talking about trustee resolutions at all in this podcast. This is all body corporate resolutions. There are three different types of body corporate resolutions: ordinary, special, and unanimous. Each have different requirements and different consensus levels. Now, how do you know when you need to take an ordinary, when you need to take a special, when you need to take a unanimous? The STSM Act, or the Sectional Title Schemes Management Act, and its prescribed rules require that some decisions be taken by special resolution and some taken by unanimous resolution. If the Act or the prescribed rules do not specify which type of resolution it is, the default position is that it is an ordinary resolution. So unless the Act or the prescribed rules specifically require a higher consensus level, being special or unanimous, you can presume that an ordinary resolution is sufficient. So there are two different ways of taking resolutions. As I mentioned, they can either be taken at a general meeting or in writing. Most often, these resolutions are taken at general meetings because, as you'll see, effectively, the consensus levels tend to be lower when taken at a meeting, but we will go through how each of these resolutions is taken in each way. But before we get there, let's talk about calculating votes in number and value. So the legislation provides for two different ways of calculating votes, and it specifies when one or both of these must be taken into account for the purposes of passing a specific resolution. So when we are talking about passing special and unanimous resolutions, the wording of the Act and the prescribed rules say that these votes need to be counted in number and value. When we're talking about an ordinary resolution, it's just being counted in value. And we'll get there, but this is just to give you some context around why I'm explaining this. So when you're calculating votes in number, and this is not applicable for an ordinary resolution, only for special and unanimous, each body corporate member is only counted once, regardless of the number of units they own in the scheme, and that's section 6.7 of the STSM Act. So if one person has 1 unit, they have 1 vote. If one person has 10 units, they have 1 vote. 1 member, 1 vote when counting in number. Okay, on the other hand, in value, it does matter how many sections you have, because the default position is that the votes are calculated according to the participation quota attached to each section when calculating votes in value. So if you have an owner with 10 sections, for example, you need to add up the PQs of each of those 10 sections. The total of that of the 10 sections PQs will be that member's voting value, whereas somebody who only has 1 section or unit will only have the PQ amount attached to that section. So the more sections you own, the higher your vote is going to be, because it's an accumulation of all the PQs of your sections. Now, the default position is calculating vote values based on PQ. However, the developer or the body corporate may have made what we call a Section 11.2 rule that varies the effect of the participation quota for the purposes of calculating vote values. And if this is the case, then the provisions of that Section 11.2 rule apply instead of the PQ, okay? And that's Section 6.6 of the STSM Act. But for the majority of schemes, when you are calculating votes in value, you are looking at the PQ values of the sections. But for those schemes which do have Section 11.2 rules, you need to look at those Section 11.2 rules to calculate the value of the votes instead. So let's move on to how to take resolutions at general meetings of the body corporate. So we are going to look at notice requirements, quorum requirements, and consensus levels for each of these resolutions. We'll start with ordinary. The notice period for an ordinary resolution at a special or annual general meeting is 14 days written notice, and that is Prescribed Management Rule 15.1. I'm not going to go into when the trustees can resolve to, call a meeting on shorter notice, slightly beyond the scope of this podcast, but in general, 14 days written notice for annual or special general meeting at which an ordinary resolution is going to be taken. So what is the quorum requirement for a general meeting at which an ordinary resolution is going to be taken? It's just an ordinary quorum. So Prescribed Management Rule 19 stipulates that where a scheme has less than 4 primary sections, 2/3 of the votes in value will be required to establish a quorum. So value, once again, PQ, unless otherwise determined by a Section 11.2 rule. Again, Prescribed Management Rule 19, if the scheme has 4 or more primary sections, it's 1/3 of the total vote values that are required to establish a quorum. Provided at least 2 persons must be present, and the value of the votes of the developer must not be taken into account for the purposes of establishing a quorum. And that's Prescribed Management Rule 19.2. So, ordinary notice period, ordinary quorum. Now, what is the consensus level for an ordinary resolution? It's a simple majority in value. So more than 50%, so 51+% of the votes in value must be cast in favor of the resolution. If you have 51+% of the PQs in favor, or the Section 11.2 rule, that will mean that your ordinary resolution is passed at a general meeting. Okay, so let's move on to special resolutions at a general meeting. For special and unanimous resolutions, the notice period is increased. It's not an ordinary notice period of 14 days. You need at least 30 days written notice to be given, unless the scheme's rules specify for a shorter period, which again, I'm not going to go into, and that is Section 6.2 of the SDSM Act. Now, the notice for the meeting must also specify the proposed resolution. So you need to include the text of the proposed resolution in the notice calling the general meeting so that people have an opportunity and they have enough time to consider the actual text of the resolution before voting on it. Once you have given your 30 days notice, including the text of the proposed resolution, what is the quorum requirement for a meeting at which a special resolution will be taken? It's just an ordinary quorum. According to PMR 19, same as we dealt with for the ordinary resolution. So increased notice period, 30 days, but ordinary quorum. Okay. Now, what is the consensus level? You need 75% in number and 75% in value of the votes to be cast in favor of the resolution. And that's Section 1.1 of the SDSM Act. It's important to note that if a special resolution is passed at a meeting where the quorum is less than 50% of the total value of all members in the scheme, the special resolution cannot be implemented for 1 week after the meeting unless the trustees resolve that immediate action is required for safety or to prevent significant loss or damage. And if during those 7 days, members holding 25% in value by written and signed request require the body corporate to hold a special general meeting to reconsider the resolution, the body corporate must do so. And that's Prescribed Management Rule 29. So effectively, we have a provision for what we call an interim special resolution. So if there are less than 50% of the total members in the scheme voting for this particular resolution, then the effect of the resolution is suspended for 1 week to give the other members in the scheme an opportunity to call for a meeting if they want to reconsider the resolution. If no request is made by 25%, then 25% in value, then the trustees can go ahead after 1 week. All right, so let's move on to unanimous resolution. Notice period is the same as for special. It's the increase to 30 days, and you need to include the text of the proposed unanimous resolution in your meeting notice. There is an increased quorum requirement for unanimous resolutions taken at a general meeting. So special and ordinary resolutions, ordinary quorum requirement. Unanimous resolution, increased quorum requirement. 80% in number and value of all body corporate members must be present or represented to form a quorum. Okay, and this is Section 1.1 of the SDSM Act. So it's an incredibly high quorum requirement. Once you have established that incredibly high quorum, all members who cast their vote at the meeting must vote in favor. Okay, so You can't have anybody voting against the resolution. Even one vote against will defeat the resolution. As for abstentions, our view is that abstentions do not count as a vote either against or for, because the section 1.1 says all members who cast their votes must vote in favor. So if somebody doesn't cast their vote, they are effectively not voting. And in my opinion, that doesn't affect the quorum. So there are some people that say that if somebody abstains from voting, that the quorum is then decreased by that person's, value and number. I don't agree with that. So in my view, you have your quorum. If you get that established, of all the people that vote at the meeting, everybody must vote in favor. And if they do, then your unanimous resolution is passed. However, where the unanimous resolution would have an unfairly adverse effect on any member, the resolution is not effective unless that member consents in writing within 7 days from the date of the resolution. And that's section 6.8 of the STSM Act. Okay, so that is resolutions taken at general meetings. Let's talk about resolutions taken in writing. Now, very interestingly and bizarrely, in my view, there is no provision in the STSM Act for an ordinary resolution to be taken in writing besides Prescribed Management Rule 79, which requires all members of the body corporate to waive their right to a general meeting to consider the resolution, and for all members to consent to the resolution in writing. So effectively, if 100% of the body corporate members waive their right to a general meeting and consent to the resolution in writing, you can pass an ordinary resolution, which is just, completely unrealistic when you're just trying to pass an ordinary resolution to get every single person in the scheme, every single member of the body corporate to vote in favor. So it's very rare that ordinary resolutions are taken in writing. Rather, they are taken at a meeting because it's much more achievable. Now, for special resolutions to be taken in writing, you need to get 75% in number and value of all the members in the scheme to consent to the resolution in writing. Okay, so it's much harder than passing a special resolution at a general meeting, because remember, for special resolutions, you only need an ordinary quorum, and then of that quorum, 75% in number and value need to vote in favor, whereas when you're taking it in writing, 75% in number and value of everyone needs to vote in favor. For unanimous resolution, to pass a unanimous resolution in writing, it must be agreed to by all members of the body corporate. Okay, so much easier to take these resolutions at meetings unless you have a small scheme and everybody's on the same page. Let's finally talk about excluded votes. A body corporate member is not entitled to vote for ordinary resolutions. They are always entitled to vote for special and unanimous resolutions, but body corporate members can be excluded from voting for ordinary resolutions if, one, they refuse to pay the body corporate any amount due by that member after a court or adjudicator has given a judgment or order for payment of that amount. And this is Prescribed Management Rule 22A. So a member is not automatically excluded from voting simply because they are in arrears. It's only if legal action has been taken either through the CSAS or through a court, and there is an award or an order that requires them to pay that money to the body corporate, and despite that order or that award, they still refuse to pay. That is when they are excluded from voting for special and unanimous resolutions. And similarly, if a member persists in breach of any of the scheme's conduct rules after a court or adjudicator has ordered that the member refrain from such breach, this is Prescribed Management Rule 22B. Again, this disenfranchisement only applies if there is an adjudication order or a judgment in place and the member continues in breach. And in addition, the value of the votes of any sections registered in the name of the body corporate must be considered abstentions. And that's Prescribed Management Rule 23. So there you have it. If you have any questions relating to body corporate resolutions or any other questions relating to community schemes, please consider joining us in Paddocks Club for fast support. We answer your questions within a 24-hour turnaround time, Monday to Friday. Visit club.paddocks.co.za for more information. I hope you've enjoyed this, and I'll see you in the next episode.